short facts of the case are that the respondent number 1 had filed a suit against the petitioner and respondent number 2 for declaration specific performance of a verbal agreement and cancellation of gift mutation number 250 attested on 30 November 1994 in respect of the landed property detailed in the heading of plaint herein after to be referred as the suit land first. According to the averments of plaint, the suit land was owned by the respondent number 1 who alienated the same to the respondent number 2 by way of gift with some conditions. First, it was further averred in the plaint that subsequently respondent number 2 transferred a portion of the suit land to the petitioner. First, it was the respondent plaintiff's case that as the respondent number 2 has refused to give him the suit land back, therefore he has filed the instant suit against him as well as against the petitioner. First, the suit was contested by the petitioner by filing his written statement wherein he pleaded that he has purchased portion of the suit land from the respondent number 2 through deed executed on 24 December 2003 for sale consideration of rupees 50,000. First, case record reveals that the respondent number 1 during pendency of his suit moved an application before the trial court for deletion of the petitioner's name, who was defendant number 2, from the column of defendants for his being an unnecessary party to the suit. First, this application was allowed by the learned trial court on 19 December 2006 first, and the petitioner's name was deleted from the suit as defendant first. Record further shows that thereafter on 20 June 2007 the respondent number 1 plaintiff and respondent number 2 defendant compromised with each other as a result of suit of the respondent number 1 was decreed as prayed for on 20 June 2007 first. This decree was assailed by the petitioner through an application under section 12 CPC. This application was dismissed by the learned trial court on 15 December 2011. First, petitioner impugned the dismissal of his application in appeal, but that too was